Hello everyone, welcome to NEOMENTORS EXAM360. Today we are going to see about the questions related to Indian polity and how we can solve the MCQs through our knowledge by eliminating the options. So the question is, which of the following is true about fundamental rights provided in Part 3 of Indian Constitution? So nothing but regarding the fundamental rights of Indian Constitution. The first is they cannot be amended as they are sacrosanct. As you know, Constitution is the fundamental law of the land, right? It is the fundamental law. Law in the sense it is a supreme law. Fundamental, nothing but it is a supreme law. That is, all the laws that we draft or we formulate through their passage in legislature, that is, it might be parliament, it might be state legislature, everything should try to uphold this fundamental law, should derive from this fundamental law. It cannot be a violation of the fundamental law, that is the Constitution. As you know, we frame the Constitution to govern us, to see that we have order, to see that we have stability, to see that the needs of the people are met, to see that we provide rights, etc. As you know, we as a society change with time, because our society, our economics, our politics, etc., they change with time. We progress. So we move in a positive direction. We try to improve our life. So similarly, we need the change in laws to improve our life. So laws can be promoter of change, or with change in our nature, that is the nature of the society, we change the law of the land as well, to see that both are compatible. Then only we will be able to move forward. So if this is a scenario, then we cannot think of a case where Constitution cannot be amended. So obviously even the fundamental rights, which are considered as the heart and soul of the Constitution, also need amendments, right? So it is not sacrosanct. We can amend the fundamental laws as well. So in this way you can eliminate this option. You could also remember the case of basic structure of the Constitution. Right? Basic structure is nothing but certain articles of the Constitution are sacrosanct, that the changing of those articles or rights or provisions of the Constitution might actually destroy the very basic foundation of the Constitution itself. So we have the concept called basic structure, which is propounded by the Supreme Court, which says that Parliament can touch any law of the land, that is even the constitutional provisions, subjected to the basic structure. We have certain provisions within the basic structure. You can check out the polity textbook. What are the articles that are considered as basic structure of the Constitution, right? So in this way, you can eliminate the first option. Next, they promote the idea of political democracy. As the name itself suggests, it promotes democracy. Democracy in the sense, it enables us, that is we, Indians as citizens, to participate in the politics of this country. So how could we participate in the politics of this country? Nothing but we can raise the voice, we can start a political party, we can try to influence the people of this country by showing them the vision of us. Okay? So nothing but all the tools that we have so that we can participate in the politics of this country. If you look at the fundamental rights, we have all the rights that are mentioned within the Constitution, that too in the fundamental rights section, that provide us those rights to participate in the politics of this country. So, of course, this option is true. That is, they promote the idea of political democracy. So this is true. The last one is, all the fundamental rights can be suspended during the operation of national emergency, except Article 21. So here too there is a caveat. It is saying that all the rights can be suspended except Article 21, right? So here too you should look at this option with suspicion. You should have doubts. How is it possible to suspend all rights, that is making states supreme to control the entire population? We, the Indians or the citizens of this country, will be deprived of all the rights of the Constitution. Do you think that scenario is good for the nation? what will be the case of the country when this right is misused by the people who are governing us, that is the government, who are running the government, the central government. So obviously we will have certain safeguards. So taking that safeguards into the mind, the framers of the constitution has said that only so and so articles could be completely suspended. So obviously you could also eliminate this option. For example, there is Article 19, which can be suspended only during external emergency. Only during external emergency. Right? That too, we have to frame law that we are violating so and so right of the people for so and so issues. So we have to frame the law, and then only we can see that the rights that are bestowed upon the people as per the constitution can be violated. You should have a cause, a just cause to violate the rights of the people. So in this way, you can eliminate the option 1, you can eliminate the option 3, and the only second one, that is the second statement, is true, that is the fundamental rights promote the idea of political democracy. So in this way, you can pick the right answer, that is 2 only. So in this way, you could use your knowledge to eliminate the option, even though you might have certain confusion whether you have remembered the facts correctly or not. So logical approach is always the better. Next is second one. Constitutional amendment in which of the following provisions would require the consent of the majority of the states, that is greater than half the number of the states that are in existence in this country. So in this, you could firstly bring the concept of federalism, that is the power that is shared between center and the states. Why? Because we have federal structure. The power is shared. Why did we share the power? Obviously to improve the administration, to provide the services to the people efficiently, etc. These are important so that the wishes of the people or nothing but the needs of the people are served. So obviously, we have the provisions in the constitution that enable us to protect these rights. So when we are changing the power structure of the constitution, which somehow deprives the rights of the states, then we require the say of the states as well, whether states are approving of the nature of the changes that are being brought to our constitution. Right? So we have to also see that the states also approve the changes in the constitution, because we are changing the parts of the constitution which could impact the states. So that is the issue here. So while solving these questions as well, we need to have certain approach. We have to see the concerning changes are actually impacting the power structure in the country or not. The first statement is qualification and appointment of the governor of the states. While reading this statement, you might be tempted that because the governor is the head of the state, maybe the state has a say on the qualification and appointment of the state. But if you observe closely how our government operates, you could simply say that governor post is more inclined towards the center, right? So governor powers are more unifying in nature. Governor is heading the state government or nothing but he is head of the state where the center, that is the power structure at the center, gives directives to the governor so that he sees that the constitution of the land is being complied by the state government. That is why he has been given certain unique powers, discretionary powers, which have not been vested to the president, but governor. Why? Because he wants to see that the state is running as per the provisions of the constitution. At the same time, the state is operating as per the directives of the center as well. That is, it is not hindering the operation of the power of the center while it is trying to execute its policies. State cannot interfere with the policies of the center. So obviously, here you could see that governor is acting as an agent of the center. If that is the scenario, so whatever the powers that governor is being vested, they have to be operating within the principles of the constitution, and obviously because they are concerning more with the center, so more than half the states' assent is not required in changing Article 157. So in this way, you could eliminate the first statement. Second statement is to amend the sharing of powers under the subject mentioned in concurrent list under Article 123. Right? So here we are talking about the subjects that are mentioned under the concurrent list. So if that is a scenario, obviously the power structure will be changing. Right? You are curtailing or you are limiting the powers of the states by changing the Article 123. So obviously that is detrimental to the federal structure. If that is the scenario, then it requires the consent of the states. So the statement 2 is correct. Next is the term of the office of president. See, state has a say on the election of the president, but not with regards to the terms of the office. Right? And as you know, president heads the state. President is a part of central, president is a part of parliament, central legislature. So his powers are mostly inclined to uphold the central government's provisions, or certain times even the states, but mostly they are with respect to the center. So obviously in deciding the terms of the office of president, states need not have any say. In this way, you can eliminate this option as well by saying that this doesn't require the assent of majority of the states. Actually, we need not take the permission from the states in deciding the terms of office of the president. Now, in this way, you could eliminate the statement 1, statement 2. So only the second statement requires the assent of majority of the states. So the correct answer is D, 2 only. The next one is the power of pardoning of the President of India. As you know, pardoning means completely absolving from the sentence that is imposed by the judiciary. Right? For example, death penalty or life imprisonment, etc. If I am pardoning, that is nothing but I am completely letting an individual go of the crime that he has committed, which led to the sentencing of him by the judiciary. And ultimately, president can look into the matter, and if he considers that the judiciary has not dealt with the issue fairly, then he could give the pardon as well. Of course, there are certain provisions, certain guidelines. Even Supreme Court has given certain guidelines to the president that he has to go through so and so guidelines and then give pardon to an individual. And pardoning power of the president also means that it is ultimately the guide here is the Council of Ministers at the center, right? He has to act as per the aids and advices of the Council of Ministers. So it is the central government which ultimately takes the decision. But nominally we call it as the power of the president. So because he is situated at the center, obviously the jurisdiction is vast. So in this way you could think that he could issue pardons on various aspects that happen within the country. So if the jurisdiction is vast, then it could not simply be limited to the central itself or central list itself or union list. It could be expanded to state list, that is the crime that an individual has committed might come within the jurisdiction of the state list. It might be from the concurrent list or even the court martials. Court martials is nothing but the operations of military tribunals. So even an individual who is from the armed forces has committed crime and the trial is done by the military law, as per the military law, by military courts, and even in these cases, president can pardon the individual who has been convicted of the crimes. So in this way, you could eliminate all the options and consider that all the lists that has been mentioned here the president has the power to issue pardoning. Now, the correct answer is obviously all the above, that is D. Next is, which of the following statements is true with respect to the preamble to Indian Constitution? So, preamble is nothing but the introductory part to the Indian Constitution. Obviously, if we read down the preamble, the basic structure to the preamble has been adopted from the objective resolution that was passed by Jawaharlal Nehru. Objective resolution passed by Jawaharlal Nehru. In this, he mentioned the vision of this country, how the nature of this country should be, what part the country should play in the future of the world, that is how it should shape the entire world, etc. So, the B.R. Ambedkar is not the one who has envisioned the preamble, it is Jawaharlal Nehru. Okay? It is a fascinating resolution, you could look into it. You could basically say that our constitution has been born from the objective resolution passed by the Jawaharlal Nehru, because he has designed the structure of the fundamental law of the land, that is the constitution. So, you can eliminate the first statement. Next one is, integrity and socialist words are present in the original preamble. So, how can I eliminate this statement? See, integrity is nothing but maintaining unity of this country. Socialist means trying to provide basic facility to the country through the interventions of the government. That is nothing but giving the responsibility to the government to take care of the citizens by providing its citizens certain services. It might be education, it might be electricity, etc., etc. Socialist government, generally welfare oriented. So, eliminating this statement is quite tricky, but you can have some certain hunch by looking at the 1976 emergency. So, during this emergency, if you look at what happened in the emergency, is the Indira Gandhi regime has opined that there are various anti-social forces that are at play, which are trying to destroy the unity of this country. So, if you are thorough with the history of the post-modern India, or post-independent India, then you could guess that probably integrity has been added because of the emergency. Similarly, socialist. So, socialism is the basic goal that Nehru has envisioned, but Indira Gandhi has taken it to the next level. For example, Indira Gandhi has nationalized banks. She has nationalized our banks. Okay? Nationalized private banks. Private banks, nothing but, for example, our State Bank of India, etc., etc. Though State Bank of India was done in 1956, many of the banks are nationalized by Indira Gandhi government. Why? Because she wants to see that the banks cater to the interests of the people rather than the rich section. So, she has taken the socialism ideology to the next level. Why? Because she was more inclined towards providing citizens the basic services rather than seeing that the services are concentrated to richer sections. Nothing but the benefits of the government policies are simply monopolized by the richer sections. That is not the goal of Indira Gandhi. So, you could say that socialism and integrity might possibly be added in the constitution during the time of Indira Gandhi, after the national emergency was imposed on this country. Third statement. So, in this way you could say that the second statement is true. Of course, this is a far-sighted guess whether this statement is true or not. But if you have certain ideas, I am saying that you could guess even the most complicated statements that are provided in this examination. The third one is 42nd Amendment Act made significant changes to the preamble. If you look at the far-reaching changes that are brought by the 42nd Amendment, you can agree with the statement. For example, changing the nature or nothing but already this is the nature of the Indian Constitution, but we are trying to show to the world as well as the people of India that Constitution has these goals as well. That is seeing that there is unity in this country. At the same time, the goal of the nation is nothing but providing basic services to the citizenry. That is why we are saying that it is a socialist state. So in this way, both second and third statements could be guessed to be true, and the first one as false. So the answer is 2 and 3, C. Sorry, integrity and socialists are not mentioned in the original preamble. I have talked on this logic, but while reading this statement, I misread it. So this second statement also could be eliminated by the idea that I have presented to you. Only 3 is the answer. That is D. Next, who among the following can dismiss the governor of a state from his office? So this is quite a basic question, but many times you could be confused regarding this as well. So we have already discussed about the nature of the office of the governor. It is more inclined towards the center, because if you look at the operations of the governor, these are nothing but trying to uphold the constitution. At the same time, seeing that state do not impede with the executive powers of the central government, right? So it should not impede. Uphold the constitution means it shouldn't violate constitution. So obviously we could guess that governor is acting as an agent of the center. So the ultimate power vests with the president with regards to the dismissal of governor from his office. So you might be confused, it might be parliament or it might actually be central government. Of course it is a central government. Of course it is done as per the decision taken by the Council of Ministers. But Council of Ministers give directives to the President, and then the President is the one who upholds or who gives assent to the direction given by the Council of Ministers, and whatever the decision that has been taken by the Council of Ministers is taken in the name of the President. So nominally we say that President has the power to dismiss the governor. Governor does not have security of tenure like the President of this country. This too could be used to guess this answer. The answer is C, President. Next, with reference to executive power in a state in India, which among the following is or are correct? Okay, that is, we are talking about the executive power of the state. So, executive power of the state is vested in governor. So you might be confused with this statement, but if you observe closely, as we have already seen, that governor is the head of the state. So all the operations of the governor are as per the directives of Council of Ministers of the state, and the decisions are taken by the governor as per the directives of the Council of Ministers of the state, and also in the name of the governor. So you might be tempted that the power is actually not vested in governor. But how the constitution reads? It reads that the executive power of the state is vested in governor. Though it is in nominal terms, but that is how the constitution reads it. So this you have to remember, or else you might be confused in the examination. So this statement is true. You could simply remember that that is how the constitutional provision provides us that the executive power is vested in governor, but that too in nominal terms, because constitution also mentions that he has to function as per the aid and advice of the Council of Ministers of States. Next, the real executive power or authority in the state is the Council of Ministers. So this too is true, right? So we are electing certain members to represent us in legislature, and the majority party could form the government, and they form the Council of Ministers to operate the governance structure of the state, thus run the government. So obviously power should be given to the elected representative rather than the governor, who is nominated by the center. or who is appointed by the president, obviously on the aid and advice of the Central Council of Ministers. So the statement 2 is also true. Next, all executive decisions in a state are taken in the name of Chief Minister. So this is a false statement. As we already seen, we have de jure, de facto rule in the Constitution, that is mentioned in the provisions of the Constitution. So the executive decisions are taken in the name of the governor. So the correct answer is 1 and 2, that is A. Next is, which of the following is true with respect to the Supreme Court of India? That is the highest adjudicative body of this country. Supreme Court jurisdiction is greater than that of its predecessor. So this you could guess. Obviously our predecessor is nothing but Supreme Court itself, but it was operating under British rule. Obviously you could say that the powers of it are lower. Why? Because British rule is not to uphold the interests of Indian nation but their nation. So if the Supreme Court is given the supreme power which could even dismantle the Britishers, then obviously it is a threat to the rule of the Britishers. So obviously they will try to control the predecessor Supreme Court. Thus, obviously the present Supreme Court has got more power than the past highest court of the land. Why? Because here we are trying to uphold the interests of the Indian nation, Indian citizens. So in this way you could say that the first statement is true. The second statement is, the Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. See, we give powers to the Supreme Court. Why? Because we want to see that it promotes justice. Justice means to uphold the rights of the citizenry. Of course, even the central government and state government too try to uphold the rights. But many times in pursuing their aims, in pursuing their goals, they might actually violate the rights of the citizens. Violate the rights of the citizens. So if this is the case, then obviously we need to have a body which could actually check the powers of the center and state so that justice is promoted in the country. So obviously if we give the power to the center and the states to reduce the jurisdiction of the Supreme Court, nothing but reduce the power of the Supreme Court, then obviously it threatens the very rights of the citizens in the country. It might lead to tyranny of the government. That is, the central and state governments becoming supreme power, curtailing the rights of the land, and few peoples operating the government such that they have all the power to take decisions with respect to where the state should travel into the future, how the state should shape itself. We cannot leave such kind of broad important decisions in the hands of few people. So in this way, we give more power to the Supreme Court to check that kind of ultimate power. So in this way, you can say that the statement 2 is true. Parliament cannot curtail the jurisdiction and powers of the Supreme Court. Next is, and here the obvious case also arises in the second statement is, Parliament can actually expand the jurisdiction of the Supreme Court. That is, it could give more powers to the Supreme Court. It cannot reduce the powers, but it can give more powers. And because ultimately adjudication is important for any country. We have judiciary, and judiciary should be independent of the state, or else if it is conforming with the wishes of the state, then obviously it will threaten the rights of the people. And we, the people, have given the power to the center to rule over us, to see that we will be able to enjoy certain rights. Without rights or without freedom, there is no meaning to our existence. That is why we have tried to gain independence from the Britishers. So if we lose the independence, or if we lose the fundamental freedoms, then there is no need and then there is no meaning to have the state. Next is Supreme Court of India came into existence on 26 January 1950. So this is true. This is a fact. You have to remember this fact. This is true. So obviously all the statements given above are true. So in this way you could guess through your knowledge. So answer is D, all the above. Next is consider the following statements regarding the appointment of judges to the Supreme Court and High Courts in India. So it is with respect to appointing the judges. The first statement given is the Constitution mentions collegium as a mechanism for appointment of judges. To change it, the recent National Judicial Appointment Committee Act, which is a constitutional amendment, has been brought out. Okay. So here, this is mostly with respect to the facts. You have to remember it. And you could also guess it through the provisions in the Constitution. It says that President appoints the judges. Okay. But it doesn't have any provisions with regard to the collegium system. So collegium system is an innovation of the Supreme Court. So it says that the President should consult the judiciary to take the decisions with respect to appointment of judges. So there is a provision with regards to consulting the judiciary, but nowhere there is a provision that President should be concurrent with the decision taken by the judges. Nothing but President should consult and then take decision on its own. That is not the case. President should agree and have the agreement of the judges. Then only he can take the appointment of the judges. Decision to appoint the judges. So concurrence means the approval of the judges is necessary. He cannot take the decision independently or independent of the judges. So this is obviously false. The statement 1 is false because collegium system has not been mentioned in the Constitution. This is the innovation of the Supreme Court. Supreme Court has given the judgments to the President because Supreme Court has the power to infer or to interpret the Constitution as it seems fit. It can attribute any meanings to any provisions of the Constitution. It can say that this word means this word means this. Or it can change the meaning of the articles. It can say that consultation means just consulting. Or it can say that consultation actually means concurrence. So in this way, it can infer any meaning from the Constitution as it deems fit. Okay. So consultation means merely consulting. I am just taking the opinion. I need not abide by the opinion taken by the judges. Concurrence means I have to have the approval of the judges. So in this way the meaning changes. And who changed the meaning of these provisions? It is the Supreme Court. Supreme Court can take its decision on its own on the merit of the judges who are in operation at that point of time. So government hadn't or didn't like the idea that it should have the concurrence with the Supreme Court judges. So government has brought in National Judicial Appointment Act to change this scenario. Of course, Supreme Court has struck it down by saying that independence of judiciary is of paramount importance and thus NJAC is not in accordance with the provisions of the Constitution because it will curtail the independence of the judiciary. Next is Article 124 of the Indian Constitution says that the judges of Supreme Court are appointed by the President in consultation with the collegium. Here consultation means concurrence. So this one is true, right? So the provisions in the Constitution reads it as consultation, but the meaning of concurrence has been given to it by the Supreme Court judges in the third judge case and second judge case. Okay. and thus it is true. So both the options or both the statements given are true. So the correct option is C, both. Sorry, the first one is eliminated. The correct answer is B, only 2. So which of the following is true with respect to writ jurisdiction of Supreme Court? Okay. So this writ jurisdiction is with respect to upholding the rights of fundamental rights. Writ means order. That means certain instrumentalities are provided in the Constitution through which Supreme Court and High Court could order the executive to take decisions as per the merits of the case, as per the decision taken by the judiciary of the land. That is giving directives that you have to do so and so. For example, if you are detaining a person without a just cause, then Supreme Court and High Court could intervene and say that the executive, that is the police officials, cannot take such decisions because it lacks merit or it has certain suspicion that it has been taken as per the agenda of certain individuals who are holding the power in the government. So it will examine whether the decision has been taken as per the legal provisions of this country, and then it will take decision. That power is obviously important to uphold the fundamental rights, that is the basic freedoms that are supposed to be availed by the citizens of this country. So with this idea, we can now read the statements. The writ jurisdiction of Supreme Court is exclusive and original. No, it is not exclusive. That is, writ jurisdiction power is not given only to the Supreme Court. Even High Court has been vested with this power. Okay, so it is not exclusive. Original in the sense, you can directly approach Supreme Court or you can directly approach High Court to utilize the power of writ from the judiciary to uphold the fundamental rights. Obviously, it is also original, but it is not exclusive. Okay, you can approach directly the Supreme Court to intervene on the matters with regards to the violation of the fundamental rights. Even High Court, you can go to the High Court and try to avail that power from the High Court to see that the issue is resolved with respect to the violation of the fundamental rights. So, first statement is false. The second one is the writ jurisdiction of High Court is wider than that of Supreme Court. So here this statement is false. With respect to Supreme Court, the writ jurisdiction is restricted only to fundamental rights, to upholding of the fundamental rights. So if there is any violation of fundamental rights, then you can approach Supreme Court to issue writs so that the issues are resolved. Nothing but promoting justice. Whereas High Court has more power. High Court can also issue writs on the matters which are not concerning with the fundamental rights as well. So the jurisdiction of High Courts is wider. For example, even if my fundamental right is not violated, my other rights are violated. For example, my voting rights. So I can go to High Court and try to plead my case with the High Court that it shall issue writs so that this issue is resolved. That is, my voting rights is restored, etc., etc. Writs are powerful instruments. Why? Because they ultimately give order to the executive of the land to take decisions as per the directions of the courts. So they are powerful. So they are used in the rarest of rare circumstances to the matters which are not concerning with the fundamental rights. So statement 2 is false. Next is, the Parliament can confer the power to issue writs to Supreme Court on matters other than fundamental rights too. This is true. So we have already seen the case where Parliament has the power to expand the jurisdiction of the Supreme Court. That is, it can enlarge the powers of the Supreme Court. Similarly, it can give the power to the Supreme Court to issue writs in matters which might not concern with the fundamental rights. So this you can guess. So the correct statements are only the one, that is third one. The first statement and the second statement are false. So the answer is C, 2 only. The appellate jurisdiction of Supreme Court constitute which of the following? So what are the appellate jurisdictions? Nothing but appealing any decision taken by the lower courts other than the Supreme Court. It might be High Court, it might be Division Court, District Court, etc. So we have various mechanisms for appealing the judgments. It has to go in a step-by-step fashion. For example, you can appeal the decision taken by the District Court in the High Court. You can appeal the judicial order of the District Court in the High Court. Then after the decision taken by the High Court, you can go to the Supreme Court to challenge the decision taken by the High Court or judgment given by the High Court. Supreme Court is the highest appellate authority. So if you have this idea that it is the highest appellate authority, then you could guess this answer. You can say that you can appeal on constitutional matters, on civil matters, on criminal matters. And even appeals by special leave is a particular instrument provided to the Supreme Court, that even if the lower courts haven't taken any decision, even if we are in the midst of a trial of an ongoing issue that is lingering in the courts, then too you could approach the Supreme Court and try to see that the Supreme Court intervenes in this matter and tries to conduct trials on this particular issue. So in this way, by having this knowledge, you could guess that all the statements or options provided are true. So the answer is C. So this ends the 10 questions that we are trying to solve through the knowledge and try to use the guesswork to eliminate the options and try to find the correct option. Thank you.